Hello, good evening, and welcome to Unacademy, a one-stop destination for the English medium civil services aspirants. This is lecture 2 of stage 1 of Conquer Prelims 2025. In the first lecture yesterday, we discussed 15 topics from current affairs related to Indian polity, which appeared in the news during this period, January to May 2024. Today, we will discuss 14 important topics. Tomorrow and day after, Saturday and Sunday, Chetan Sir would be live at the same time to discuss current affairs related to international relations. So press the like button, subscribe to our channel if you haven't yet, and let's get started and look at topic number 1, which means topic number 16 in total. Bilkis Bano case. Bilkis Bano was the survivor of a rape which happened during the Gujarat riots of 2002. Then the accused were arrested, investigation took place, but the Supreme Court directed that this investigation should be handed over to CBI. And then there were allegations of, allegations of mistrust, maybe the trial may not proceed fairly in Gujarat. That is why this trial was shifted to Maharashtra. And then these convicts, they had served more than 14 years in jail, and later on, the government of Gujarat released them after they have completed more than 14 years in jail. Then the matter went to the Supreme Court, and Supreme Court said, no, this is not legal. And that is why this topic becomes important for your examination. First and foremost, when it comes to Article 72 and 161 of the Constitution, both the President and the Governor, what they have the power to pardon, commute, remit, respite, or reprieve. That's what we call the clemency powers, the pardoning powers. That's related to the static syllabus. Please revise, can be important for your exam. Very briefly, what is pardon? If you have committed a crime and now the president or the governor, on the advice of the government, because president and the governor, they cannot exercise this power on their own at their discretion. They have to abide by the recommendation of the Council of Ministers, recommendations of the cabinet, recommendations of the government. What if the president pardons you? What does that mean? That means not only are you released from the jail, but any disqualification which may be attached to your conviction, that is also gone, which means you can be as good as a child born out of the womb of the mother, which means, I'll give you a simple example. For example, a politician has been convicted and sentenced to jail, let's say 5 years jail. Once you are in jail, during this 5-year period, you cannot contest elections. But once you are released, you are disqualified from contesting elections for a further period of 6 years. That means 6 years after your release, you cannot contest elections. Now, if the president or the governor pardons you, not only will you be released from the jail, but this disqualification which is attached to it, which means you cannot contest elections for 6 years, that's also gone. That means tomorrow you can contest elections. That's what we call pardon. That means absolving you of all the guilt, of all the convictions, all the disqualifications. Second is commutation. And commutation is normally used in terms of death penalty. For example, you were awarded death penalty, which can be commuted to life imprisonment. Then we have something called remission or remit. You were given 14 years in jail, but now this 14 years in jail can be reduced to 10 years in jail. That means your sentence has been reduced. Who has this power? Although pardoning powers are available with the president and the governor, who exercise these powers on the advice of the government, but the Criminal Procedure Code, which means prison is a state subject. And if you are a prisoner, you are an inmate, whether you can be released before the term or not, that is the prerogative of the state government. And that power is provided under Section 432 of the Criminal Procedure Code. Similar provision exists in BNSS, Bharatiya Nagarik Suraksha Sanhita. And there is section 473, which talks about similar provision as it existed in CRPC of 432. But what this section did, it imposed a limitation. What is that limitation? Listen to me carefully. If you have been sentenced for a jail term, you have been convicted for a crime for which death sentence was an option, but you were not given. Death sentence was an option, but you were given life imprisonment. Or death sentence was given, but that death sentence was commuted to life imprisonment. Now, if you were given death sentence, which was commuted to life imprisonment, which means if you are serving your life in the jail, you can also be released. You cannot be released unless and until you have served 14 years in jail. This was the limitation under section 432 of the Code of Criminal Procedure. Now, those convicts in the Bilkis Bano case, since they had already served more than 14 years in jail, now they approached the Gujarat government that please release us because we have completed more than 14 years in jail. Now we are eligible that our sentence be remitted. And the government, what it does, it takes a look at the conduct of this prisoner, it takes a look at the behavior of this prisoner, and ultimately recommends to the government that you can release this person after he has completed more than 14 years in jail. For that, Supreme Court has issued guidelines. Lakshman Naskar versus Union of India, way back in 2000, the Supreme Court has laid down 5 grounds on which remission is considered. Because this power to remit the sentence cannot be arbitrary. It has to be based on some logic, based on some solid consideration. And those guidelines have been laid down by the Supreme Court in the year 2000. Maybe this question can be asked. Which of the following are the guidelines released by the Supreme Court under which remission can be considered? 5 conditions. Condition number 1, whether the offense is an individual act of crime that does not affect the society. You have committed a crime, but maybe you have committed a crime against your family members, which may not affect the entire society. Maybe. Second, there is a chance that you will recommit the offense. If that is the case, then remission should not be granted. Whether the convict has lost the potential to commit another crime. Maybe you are now too old to commit a crime. You are too weak to commit a crime. You can't even hold the revolver in your hand or a knife, which means you have lost the potential to commit a crime. Your sentence can be remitted. Whether any purpose is being served in keeping the convict in prison. Because the golden rule of criminal justice system is to reform the offender. Why punishment is given for a crime? There are 2 objectives. 1, to reform the offender. Second, to deter future commission of crimes. Why should a punishment be given for a crime? If I have committed a crime, I am sentenced to jail. It sends a signal to the outside world that if you commit this crime, you will also go to the jail. So this is to deter future commission of crimes as well as to reform the offender. Whether you are reformed or not, we have to analyze. If you have been reformed, then your sentence can be remitted. And the court also has said we have to look at the socio-economic condition of this convict's family. Maybe you are the sole breadwinner. Maybe your family will starve if you are not released. These conditions are to be considered while a remission can be decided by the government. But in Bilkis Bano case, what the Supreme Court said not the Gujarat government, it is the Maharashtra government which has the power to remit the sentence awarded to these convicts in the Bilkis Bano case. This can be an important statement for your prelims exam. Because who has the power, which state government has the power to remit the sentence? Is it the state government where the crime was committed? Or is it the government where the trial was completed? Although the crime was committed in Gujarat, but the trial got completed in Maharashtra on the directions of the Supreme Court. So now the Supreme Court has said that these convicts who have been released, they could not have been released by the Gujarat government because although the crime was committed there, but the state where the trial completed was Maharashtra. So it is the Maharashtra government which has this power. That can be important statement for your exam. Also, when you look at this Bilkis Bano case, there are also various other unnecessary details. For example, these convicts approached the court that we should be granted remission based on the 1994 prison rules, not under 2004 rules. So what is that 1990 rule? What is that 2004 rule? You don't have to get into that, irrelevant for the examination. What you need to understand is this. Let's look at the question. Which of the following statements is or are correct? I'll give you 1 minute to answer this question. The governor of a state can pardon a death sentence. In case a convict is serving life imprisonment, the president or the governor can exercise clemency powers only after the convict has served a minimum of 14 years in prison. Which of these statements is or are correct? Let me know what is the right answer. The governor of a state can pardon a death sentence. This is incorrect. You might have read in the newspapers, now the Supreme Court has said that governor can also pardon a death sentence. That is incorrect. What the court has said, if you have been convicted for a crime, listen to me carefully, if you have been convicted for a crime for which death sentence was an option, but death sentence was not given to you, you were given life imprisonment, but you have committed this crime for which death sentence was an option, governor has the power to pardon you, because governor cannot pardon a death sentence, but governor can pardon a sentence for a crime for which death sentence was an option, but was not given, life imprisonment was given. So still governor cannot pardon a death sentence, keep that in mind. Second, in the same case, this was related to Tamil Nadu case, where the assassins of Rajiv Gandhi, their remission was to be taken under consideration. The court has said that if you have committed a crime for which death sentence was an option, but death sentence was not given, life imprisonment was given. Under the Criminal Procedure Code, you have to necessarily serve 14 years in jail. After that, your sentence can be remitted. That's what we have discussed, Criminal Procedure Code and a similar provision which exists under BNSS. But the court in this case said that does not apply to president or the governor when they exercise their pardoning powers under Article 72 and 161. That means the president and the governor can pardon you, can remit your sentence even before completing 14 years in jail. Even before. If the state government wants to exercise the power under Criminal Procedure Code or BNSS, then this convict necessarily has to complete minimum 14 years in jail. But if not this, then can the president or the governor remit the sentence to this individual even without completing 14 years in jail? Yes. That is why both these statements are incorrect. D is the right answer. Let's look at topic number 2, difference between parole and furlough. You need to understand that prisons, as I told you previously, comes under state list. When it comes to matter related to Gurmeet, Ram Rahim and various others, for example, Mr. Chotala also released on parole, furlough multiple times. That is why this topic is important. In fact, 2021, this question was asked in the prelims examination. With reference to India, consider the following statements. When a prisoner makes out of sufficient case, parole cannot be denied. Whether this is correct or incorrect, let's understand what is the difference between furlough and parole. For that, first keep in mind, prisons comes under state list. And for that, there is an old law called Prisons Act of 1894. Although there is another Model Prisons Act enacted in the year 2023, which we will discuss today in this class. But keep in mind, right now, the states, they have these prison rules governed under Prisons Act of 1894. What is the difference between parole and furlough? The fundamental objective is to reform the convict, because I told you what is the basis for punishment. Why should you be punished for a crime? There are two reasons. One, to reform an offender, and to deter future commission of the crimes. Reform is very important. What if you have served many years in jail, but after a few decades you are released? you will not adapt yourself to the environment because the environment may have changed. For example, if you have watched that movie, Shawshank Redemption, starring Tim Robbins, there one individual, Mr. Brooks, was in the jail for many decades. Then he was released. He could not adapt to the outside environment, and ultimately he hanged himself. Mentioning Brooks was here. So you need to reform the offender and periodically allow them to go back to the society so that they are not too away from the rest of the society. That's the fundamental objective of parole and furlough. But parole is not a right. Parole is given at the discretion of the government, discretion of the jail authorities. Why? Maybe for a specific reason, such as there is a death in the family or there is a wedding of the blood relative. In that case, you can be released on parole, but at the discretion of the prison authorities. It's not your right. It is our discretion that we are releasing you on parole. And for that, strict conditions will be mentioned. You cannot go out of the district. You have to periodically report before the police. And at the same time, you should have exhibited good behavior while in prison. Then parole can be given. But furlough is seen as a matter of right without any reason. Because for parole, there has to be a specific reason why you are released from the jail. But for furlough, there is no reason. Irrespective of any reason, you can be released on furlough because furlough is your right. Because we want to reform you, we want to give you time so that you can stay connected to the rest of the society. But for furlough, whatever your sentence was, listen to me carefully. If you were given 10 years in jail, but now you are released on furlough for, let's say, 20 days. Does that mean you will now have to serve 10 years plus 20 days in jail? No. These 20 days will be treated as part of your sentence. But when it comes to parole, your parole period is not included in your prison sentence. Which means if you're released on parole for 15 days, you have to serve those 15 days in jail as well. That is the difference between the two. There is something called regular parole, which I was talking about. There is a death in the family, there is a blood relative's wedding. For some specific reasons, you are granted parole. That is a regular parole. But sometimes the superintendent of a jail can also grant you parole for 7 days in case of emergencies. Any emergency, you can be released on parole by the superintendent of the police for 7 days. Otherwise, there is a panel which recommends whether you should be released on parole or not. That's the difference between the two. Parole, as I said, is granted by the state executive because prison is a state subject. That is why these parole and furlough rules, they may also vary from state to state because prisons is a state subject. But the parole which is granted by the state executive, by the state government, the jail authorities submit the report to the state government. And ultimately, it is the authority that takes the decision whether to grant you parole or not. That is regular parole. But in case of emergency, the superintendent of the jail has the power to release you on parole for 7 days in case there is emergencies. Parole can be granted number of times, but there is a limitation to the number of times furlough can be granted. Parole can be granted for any prisoner, but furlough is granted only for those prisoners who are serving long years in jail. But there are also conditions. If you have committed a crime against a woman, if you have committed heinous crimes, maybe you will not be released on parole. But furlough is for those who are serving long term in the jail. That's the difference between the two. Can be important for your exam because if it has been asked in 2021, who knows, it can be asked again. So what is the answer to this question? When a prisoner makes out a sufficient case, parole cannot be denied to such a prisoner because it becomes a matter of his right. Parole is at the discretion of the government. It is not a matter of right for the prisoner. Furlough is the right. Clear? State governments have their own prisons released on parole rules. Why? That is correct because prison comes under state list in the distribution of powers. So which of these statements are correct? B, 2 only is the right answer. Clear? Very good. Let's look at another topic, Chief Election Commissioner and other election commissioners, appointment, conditions of service and terms of office Act 2023. Election Commission of India is what? It is a constitutional body. Under Article 324. And Constitution says that this Election Commission of India shall consist of Chief Election Commissioner and as many election commissioners as may be appointed by the President. And you would know that till 1989, Election Commission of India would function as a single member body. There was only a Chief Election Commissioner. Election commissioners were not appointed. Later on, a law was passed in the year 1991. Then election commissioners also got appointed by the President. Although Constitution says that the Election Commission of India shall consist of Chief Election Commissioner and as many election commissioners as may be appointed by the President, but how this appointment would take place, for that there needed to be a law. There was a need for a law, how this appointment will take place. But such a law was never enacted by the Parliament. Although 1991 law was enacted, but this law only provided for that at maximum 4 election commissioners would be appointed. So the Election Commission of India, according to this 1991 law, will consist of Chief Election Commissioner and maximum 4 election commissioners. We can have less than 4 as well, but maximum 4. But how this appointment will take place, how CEC and election commissioners will be appointed, for that there was a need for a law, but this law was not enacted by the Parliament right from the commencement of the Constitution. And matter went to the court. Which was that case? Anup Baranwal versus Union of India. Supreme Court said, since there is no law, what we need to do, till the time Parliament enacts a law, we will say that the President shall appoint Chief Election Commissioner and the election commissioners based on the recommendations of a committee. And this committee will consist of the Prime Minister of India, leader of the opposition in the Lok Sabha or the leader of the single largest party in the Lok Sabha, and the Chief Justice of India. This was the Anup Baranwal judgment. Immediately after this judgment, Parliament enacted this law. And now this law is something which can be important for your examination. Why? I'll tell you the reason. This law, which was passed in 2023, it replaces the 1991 law, which I was talking about in the previous slide. And that law was Election Commission, Conditions of Service of Election Commissioners Act 1991. Now that 1991 Act has been repealed. It has been replaced by this law, which was enacted in the year 2023. According to this law, these Chief Election Commissioner and election commissioners will be appointed by the President, but now on the recommendations of the Selection Committee. What will be the composition of the Selection Committee? Selection Committee will consist of the Prime Minister, leader of the opposition in Lok Sabha or the leader of the single largest party in Lok Sabha, and a Union Cabinet Minister nominated by the Prime Minister. So replacing Chief Justice of India, now we have a Union Minister, Cabinet Minister nominated by the Prime Minister. That is the change. But how will this Selection Committee select a candidate for CEC and election commissioners? For that, the Law Minister will set up a search committee. You might have read that this search committee will be headed by the Cabinet Secretary, which is not the case. That was part of the original bill, but that bill was changed. Now this search committee will be headed by the Union Minister of Law and Justice, and this search committee will propose 5 names. And these 5 names will be sent to this selection committee, and selection committee will have a look at these 5 names and accordingly recommend to the president who should be appointed as the election commissioner or chief election commissioner. But listen to me carefully. Can this selection committee choose a name which is not part of this panel shared by the search committee? Yes. That means even if the search committee has not recommended this name X, even then this name X can be considered by the selection committee and can be recommended to the president for the appointment. And the salary, conditions of service of chief election commissioner and the election commissioners will be equivalent to that of the judge of the Supreme Court. Right or wrong? Right. 5 names, as I said, but the selection committee may consider any person other than those suggested by the search committee. Now listen to me carefully. Our current chief election commissioner is going to complete his term because you hold office till the age of 65 years or 6 years at Election Commission of India, whichever is earlier. Once you're appointed as the chief election commissioner or the election commissioner, you will remain in office till you complete the age of 65 or for 6 years at the election commission, whichever is earlier. Now our chief election commissioner is going to complete his tenure in February, and now we have to appoint a new chief election commissioner. Now for this new chief election commissioner, this search committee will recommend few names to the selection committee, which will happen for the first time. Normally, an election commissioner is promoted as the chief election commissioner. But this time, according to media reports, this search committee will give 5 names to the selection committee. And selection committee may choose an outsider also as the chief election commissioner. So maybe the 2 election commissioners that we have, one of them may not be promoted as the chief election commissioner, but then somebody recommended by the search committee may be appointed as the chief election commissioner. Maybe. That is why this topic becomes important for your examination. Clear? Let's look at another topic, political parties and income tax. Just before the 2024 Lok Sabha election, there was this news floating around that income tax notice has been sent to the Congress party and they have to pay income tax, for which the bank accounts of the Congress party were also frozen. And then later on what happened, we don't have to get into that. We just have to understand the polity news from this political news. Are political parties exempted from paying taxes? Yes. How much? 100% tax exemption from all sources of income. No matter what your income is, you are exempted from paying tax if you are a political party. Where is it mentioned? It is mentioned under the Income Tax Act. But then, sir, why was tax notice sent to the Congress party? Although you are exempted from paying taxes from all sources of income, even then you have to submit your income tax returns. Just like taxpayers, individual taxpayers, every year they have to file income tax returns, annual ITRs. Political parties also have to do that. Although they don't have to pay the tax, but they have to file their income tax returns. And they have to file this by the 30th of September every year. If you do not file these returns by the 30th of September every year, then you have to pay tax for that financial year. That means in a particular financial year, if you have not submitted tax returns with the income tax authorities, then you are liable to pay full tax on that entire financial year. It was because of this reason that Congress party had failed to submit their income tax returns to the income tax authority by the 30th of September, which means they missed the deadline to file these income tax returns. That is why under Representation of the People Act, because you have to submit this report to the income tax authorities under the Representation of the People Act. Although you are tax exempted under the Income Tax Act, But even then, you have to file your returns under the Representation of the People Act, because you have to submit these details to the Election Commission as well. If you fail to do that, then you have to pay income tax for that entire financial year. That is what you need to understand. You don't have to go through the political news. Just understand whether political parties are exempted from paying tax. Yes. How much? 100% tax exemption. But even then, they have to file income tax returns. Just like individual taxpayers, they file their returns. Political parties, their treasurer, they have to submit these details by the 30th of September. If they fail to do that, if they miss the deadline, then for that entire financial year, they are liable to pay tax. Is that clear? Salary will be equivalent to Cabinet Secretary under 2023 Act. No, my dear, that was part of the original bill. So when originally the bill was introduced in the Parliament, it was said that this search committee will be headed by the Cabinet Secretary and the salary will be equivalent to that of the Cabinet Secretary. But that was changed later. The final bill which was passed, it mentions salary will be equivalent to that of the judge of the Supreme Court. Let's look at another topic, the VVPAT judgment, and listen to me carefully. We have electronic voting machines. When were EVMs used for the first time? At a by-election to Parole constituency in Kerala, way back in 1982. But this by-poll was declared null and void by the Supreme Court. Why? Because the Representation of the People Act explicitly provided for the use of ballot papers for conducting elections, not EVMs. That is how this by-election was declared null and void, because the Election Commission had used the EVMs for the first time. Later on, this Representation of the People Act was amended, and then this Representation of the People Act provides for the use of electronic voting machine. And since 2004, we have been using EVMs in all the elections to Lok Sabha and legislative assemblies. Which means prior to 2004, we were also using EVMs, but not in all the constituencies, not in all the polling booths, in majority. But from 2004 onwards, we have been using only EVMs, not the ballot papers. Right or wrong? Right. And then these EVMs, there was one flaw with the EVM, and that was the lack of transparency. Don't go by what political parties will say, that EVMs can be hacked, EVMs cannot be hacked. There are strict safeguards available with EVMs, and that is why EVMs cannot be hacked. One primary reason is that in EVMs, which is manufactured in India, and there are two public sector undertakings which manufacture them. One is based out of Bangalore, the other is based out of Hyderabad. One, Bharat Electronics Limited, the other Electronics Corporation of India Limited. Two public sector undertakings. But EVMs are not connected to the internet, cannot be connected to the internet, which means these EVMs do not have the transmitter, these EVMs do not have the receiver. When you don't have the transmitter, you don't have to have the receiver, which means you cannot be connected to the internet. When you cannot be connected to the internet, which means you cannot be remotely operated. And if your phone can be remotely operated by me, that means I have hacked into your phone. But I can hack into your phone because your phone is connected to the internet. But EVMs are not. EVMs are like calculators. And you would have never heard that that your calculator has been hacked. Calculator may malfunction, may stop functioning, but cannot be hacked. But be that as it may, that's besides the point. Lack of transparency was, if I press the button on the electronic voting machine, I don't know whether my vote has been registered in favor of the candidate of my choice or not, because the details were not visible. That's how in 2013, VVPATs were introduced. For the first time at a constituency in Nagaland, Noxon. VVPAT stands for Voter Verifiable Paper Audit Trail. Not trial, trail. So as soon as you press the button on the electronic voting machine, for 7 seconds, some information gets displayed. What is that information? The serial number of your vote, the name of the candidate against whom you have voted, and the symbol of the political party. This can be important detail for your prelims examination. And when this information gets displayed for 7 seconds, then this VVPAT slip is cut and drops into the VVPAT box. Right or wrong? Right. But then we also need to see whether the votes which are polled and recorded in EVM, whether they match with the VVPAT slips or not. So we need to verify. Although we are only counting the EVM, but just to check, can we have a sample from which we can take these VVPAT slips and say from this polling booth, VVPAT slips counting shows 100 for A, EVMs also show 100 for A. That means it is a foolproof system. Previously, what Election Commission of India would do, it will take one VVPAT per assembly constituency in a parliamentary constituency. What does that mean? In a parliamentary constituency, there are lots of assembly constituencies, assembly segments. So what Election Commission of India will do, it will randomly pick one VVPAT from one assembly constituency in a parliamentary constituency, count it, and then check it with the EVM and see if there is a mismatch. 2019, Mr. Chandrababu Naidu's party approached the Supreme Court and said, no, we need to increase this number of verification. We can't have just one VVPAT per assembly constituency in a parliamentary constituency, and basis this we can say EVMs are safe. We have to enhance the sample size. And then in 2019, the Supreme Court said, now instead of one, we will have 5 VVPATs per assembly constituency in a parliamentary constituency. These needs to be verified and cross-checked with the EVMs. Then matter went to the court again. And this was last year. Matter went to the court again. And the petition was, my lord, we should go back to the ballot papers. Supreme Court said, no, we cannot set the clock back. We cannot go back to the past. We are not going to go back to the ballot papers. Then the petition was that we need 100% VVPAT verification. That means all VVPAT slips needs to be counted and then checked with the EVMs. Supreme Court rejected even this. But what Supreme Court said? 2 things. If you have come second or third in the election, the winner, I am the winner, you are at serial number 2, the other person is at serial number 3. After the election results have been declared, if you can petition the Election Commission, then what Election Commission will have to do? Will have to verify 5% VVPAT. Not 5%, but you have to bear the cost. Cost that will be incurred upon cross-checking and counting these VVPAT, 5% VVPATs, you will have to bear that cost. And if at the end it is proven that you were right, the VVPAT and EVM, they are not matching, we will reimburse you that money, but you will have to bear that. That's what Supreme Court said, number 1. Number 2, there is something called SLU. Symbols Loading Unit. It's a matchbox shaped device which is connected to your computer or a laptop, and through this you load symbols on the electronic voting machine. So the device which is used to load symbols on the electronic voting machine, that is what we call SLU. And Supreme Court has said that this SLU should be saved for 45 days after the results have been declared, so that if somebody says that while loading the symbols, there was some discrepancy, there was some hanky-panky done by the Election Commission or by the election authorities, then you can examine these symbols loading unit for 45 days. The election authorities will have to store these SLUs after the results have been declared. That's what the Supreme Court has said. And that's all that you need to know. So what you need to know, few details about EVMs, few details about VVPAT. VVPAT is Voter Verifiable Paper Audit Trail, used for the first time in 2013. How many can be verified physically with electronic voting machine? That number. So it is not 5%, it is 5. 5% is if you have come second or third in the election and you doubt the veracity of the election results, then you can file a petition, and then the Election Commission will have to count 5% of the VVPAT slips. And these symbols loading unit, it has to be stored for 45 days after the results have been declared, so that within 45 days, if you want to question, you can do that. Okay? Any questions as of now? Okay. Now let's look at what is Form 17A and what is Form 17C. Lots of petitions on this as well, some controversy as well. We just need to have a brief idea of what is Form 17A, what is Form 17C, and that's done. What is Form 17A? This is part of the Election Conduct Rules of 1961. What these rules say? You are a voter. You enter the polling booth. Your details will be captured by this form known as Form 17A. Details such as, what is the serial number of the elector you have entered? What is your serial number on the electoral roll? What is the detail of the document that you have provided, your identification, whether voter card or any other card? What is your signature as well? This is called Form 17A. So Form 17A will tell us, for example, you are attending a workshop and at the time of the entry, you make your details, you mention your details. After that, you are allowed entry inside that seminar hall. That is called Form 17A. Form 17C is different. Form 17C talks about further details. How many electors were assigned to a polling station? For example, in a polling station, 1200 to 1500 electors are assigned. That means one polling booth should cater to 1200 to 1500 voters. That number is mentioned in Form 17C. Total number of voters as entered in 17A. So you have entered the polling station, you have filled your details under Form 17A. This detail will also be captured in Form 17C. But apart from that, number of voters deciding not to record votes under Rule 49O. And listen to me carefully. Before Nota came into the picture, Nota is none of the above. The last button on the electronic voting machine. If you're not happy with any of the candidates selected by political parties, you can press Nota. That means you disagree with all the candidates set up by political parties. Prior to Nota, there was something called Form or Rule 49O, which means you have entered the polling booth. Your details are now mentioned under Form 17A, but you enter the polling booth and you say, I refuse to vote. I reject this election exercise. I refuse to vote. What the polling authorities had to do, it had to record your details and say that these are the individuals whose names were mentioned in Form 17A, but they have refused to vote because of whatever reasons. Your details will be mentioned under this Rule 49O. But this 49O was declared unconstitutional by the Supreme Court. Why? Because it violates secrecy. Because the golden characteristics of any voting machine that we use or any voting system that we use, it must fulfill 4 criteria. 1, it has to be anonymous. 2nd, it has to be accurate. 3rd, it should be scalable. 4th, it should be full of speed. That means it should produce results very quickly. These are 4 important characteristics of any voting system that we use. Anonymity is very important because I don't want to be victimized later. Why did you refuse to vote? But those details are mentioned under Rule 49O, although declared unconstitutional, but nevertheless, it is still part of Form 17C. Number of voters not allowed to vote. The polling authorities may say, no, you are not allowed to vote because you are not mentioned as the voter, or you have faked something. Whatever the reason, you are not allowed to vote. Those details are also to be mentioned. Total number of votes recorded under 49MA needs to be deducted. 49MA, now listen to me carefully, this can be important. Why important? I enter the polling booth, I have to now vote, and I see something fishy going on. I say the EVMs are malfunctioning, or in EVMs, votes were already recorded. This entire exercise is bogus. So you are leveling allegations about the fairness of the election process. Now, in your presence, test vote will be recorded. Now, let's test your allegations, whether you are saying right or wrong. Those test votes are now to be deducted because those are not real votes. We are doing this just to test whether the EVMs are working correctly or not. And for the first time, if you are making a false allegation that you are questioning the fairness of the election process, for that the law says you can be sentenced to simple imprisonment for 6 months. An Election Commission of India has said that we may use this very rare provision to penalize those who are leveling false accusations on the fairness of our election process. But long story short, it is this Form 17C which will tell us the real picture about the voting percentage. How many voters were assigned to this polling booth, but how many entered, how many voted, how many refused to vote, how many were not allowed to vote, how many raised question marks about the fairness of the election process. This detail is very important. And that is how petition was filed, that this Form 17C should be made available on the Election Commission of India website, should be made available for the public. But Election Commission of India said, no, we can't do that because we don't have any legal mandate to make it public. But a question can be asked in the examination, is this detail shared with anybody? It is. It is shared with whom? It is shared with the candidates or the agents of these candidates. So Form 17C details are not shared with anybody. Whether this statement is correct or incorrect, it's incorrect because it is shared with the candidates or their agents. What is captured in Form 17A? What is captured in Form 17C may be asked in the examination. That is why we need to understand it. Clear? Okay. Let's look at another topic, electoral trusts. Electoral bonds were declared unconstitutional by the Supreme Court in the ADR case. And we have discussed very briefly about that yesterday. But is there another way through which political parties raise money, generate funds? That is electoral trusts. If the question has not been asked on electoral trust till now, maybe this year you may expect a question on electoral trust because electoral bonds have been declared unconstitutional. What are these electoral trusts? It is a trust which is set up by companies. Which companies? Those companies which are registered under the Companies Act, under Section 25 of the Companies Act of 1956. All those companies which are registered under the Companies Act, they may set up a trust called electoral trust. What is the objective of this trust? The only objective is to raise money from other companies, from individuals, And then this money which I have raised as an electoral trust, I have to now give it to donate it to political parties. So the electoral trust is a trust which is set up by companies with the only objective that we will generate money from other companies and other individuals and donate it to the political parties. When was this scheme announced? It was announced in 2013. But please understand, electoral trusts were existing prior to 2013 as well. Important statement for your exam. They were in existence prior to 2013 as well. But they got legalized by a scheme when UPA was in power in 2013 called Electoral Trust Scheme. Because in 2013, the government did what? The government specified who is eligible to set up this trust. How do you register this trust? How will you receive this money? Who is eligible to donate money? Who is not eligible to donate money? Which are these companies which are eligible to donate money to this trust? And for that, look at this slide. Can be important for your exam. This electoral trust may receive contribution from whom? Somebody who is the citizen of India. That means not only companies, somebody who is a citizen of India. A company registered in India. A firm registered in India. A Hindu undivided family. Association of persons who are Indian citizens. They may form an association. So whether an association or a firm or a company or an individual or a Hindu undivided family, they can donate money to this electoral trust with the single objective that now you donate it to the political parties. But it is different from electoral bonds because this is not anonymous. So we get to know that these are the companies which are donating money to this trust. And then this trust is donating money to political parties. And from which trust, how much money is received by a political party, that is also known. So this is not anonymous. But who cannot contribute to these electoral trusts? Foreigners, foreign companies, those electoral trusts which are not approved under the electoral trust scheme. Which means there is one electoral trust and then there is another electoral trust. Can an electoral trust receive contribution from another electoral trust? No. You can receive contribution from individuals, companies, firms, Hindu undivided family, but you cannot receive contribution from another electoral trust. You cannot receive donations from somebody who has not shared the PAN, the permanent account number. And you cannot also receive donations from NRIs who don't have the Indian passport. So this electoral trust scheme of 2013 makes it clear who can set up this electoral trust? Companies registered under the Companies Act. And you can receive contributions from them, but you can't receive contributions from these entities. That is electoral trust. But something very important. If an electoral trust, let's say, raises 100 crores from individuals, from companies, from firms, from Hindu undivided family, 5% of these funds, this electoral trust can use for administrative expenses. That means maybe for rentals, maybe for salaries for the employees. But the remaining 95% has to be donated to the political parties. As I told you, there were electoral trusts prior to 2013 scheme as well. And there were six such electoral trusts. They donated money to political parties before 2013. But these rules which were made in 2013, these rules were not retrospective. They were prospective. So to which political parties, who were the donors to these 6 electoral trusts prior to 2013 scheme, it is not known. Long story short, what is an electoral trust? Political parties can raise money from various sources, directly from the people, from charging their political workers, membership fee. They may receive donations from companies directly. Now, they cannot raise money through electoral bonds, but they can raise money through electoral trust. And what is a trust? A company sets up an electoral trust with the principal objective of receiving contributions from others so that it can donate to a political party. But this electoral trust scheme was launched in 2013, which made it absolutely clear who can donate to these electoral trusts, who cannot. And you can donate 95% of your funds, which you have generated, raised, but 5% you can keep for your administrative purposes. But prior to the scheme, there were 6 electoral trusts. Who was donating to them? That is not known, because these rules were not retrospective. That can be an important statement for your exam. One more thing and this topic is done. Electoral trust route is transparent on contributors and beneficiaries. That means who is contributing, who is the beneficiary, we get to know. Who is contributing money to this trust, and this trust is donating to whom, everything is known. But it becomes easier if there is only one contributor and only one beneficiary. For example, there is one electoral trust called Janhit Electoral Trust. It had only one contribution from one contributor and only one beneficiary. Contributor was Vedanta, which donated 2.5 crore to this trust, and the beneficiary was also one, the BJP. But what if there are many contributors and many beneficiaries? Listen to me carefully. This electoral trust, for example, Prudent Electoral Trust. This is one electoral trust. It receives contributions from many companies, for example, Bharti Airtel, DLF, GMR. But it donates money to various other political parties, some regional parties, some national political parties as well. So we don't know whether Bharti Airtel gave this money to this electoral trust to give to the BJP or to the Congress. We don't know. If there was only one contributor and one beneficiary, we would know, just like Janhit Electoral Trust. But if there are many contributors and many beneficiaries, we would not know which company or which individual has donated to this trust for which political party. That is the electoral trust scheme, and that can be important for your exam. Okay? Okay. Let's look at National Human Rights Commission. National Human Rights Commission is what? It is a statutory body. Statutory body means a body which is created by the law passed by the Parliament. And which is that law which created NHRC way back in 1993? It was Protection of Human Rights Act. Additional detail, it is in conformity with the Paris Principles. Paris Principles, which says that all these national human rights institutions, they should be fair, without any political pressure, without police pressure. They should be fair in upholding the human rights of the citizens. These Paris Principles were adopted at the first international workshop on national institutions for the promotion and protection of human rights, which was held in Paris in 1991. So all these human rights institutions across the world, they came together, attended this first international conference on human rights and adopted this Paris Principle. And these Paris Principles were later on endorsed by the General Assembly of the United Nations in 1993 as well. And in conformity with these Paris Principles, we enacted a law called Protection of the Human Rights Act. And this act created National Human Rights Commission, which is a statutory body. Now, this National Human Rights Commission, this law also creates States Human Rights Commission. NHRC, National Human Rights Commission, State Human Rights Commission as well, in all the states. One law. But prior to some changes which were made in 2019, So this is a very important topic, can be asked in the examination, supremely important topic. This law, when it was enacted in 1993, it was changed also multiple times, and the last important change happened in 2019. What was the change? Prior to that, the National Human Rights Commission would be headed by a former Chief Justice of India. In 2019, the law was changed to say that this National Human Rights Commission would be headed by a former Chief Justice of India or a former judge of the Supreme Court. Similarly, for States Human Rights Commission, previously the condition was that the chairperson of the SHRC would be the former Chief Justice of a High Court. Now, because of the changes, now we say the chairperson of the States Human Rights Commission should be a former Chief Justice of a High Court or a judge of the High Court. This act previously would provide that there should be two people who should have, if they have the knowledge, expertise of human rights, they can be appointed as the members of the NHRC. In 2019, the law was changed and said, instead of two, we will have three people who have experience and expertise in human rights. They can be appointed as the members of the NHRC. And at least one has to be a woman. Previously, chairpersons of various commissions, such as National Commission for SCs, National Commission for STs, National Commission for Women, they were the ex officio members of NHRC. So NHRC will have a chairperson. It will have three members who have the experience and expertise in human rights. And then there will be ex officio members, which means if you are the chairperson of the National Commission for Scheduled Castes, National Commission for the Scheduled Tribes, National Commission for Women, you are the ex officio member of this NHRC. In 2019, further ex officio members were appointed. Now, if you are a chairperson of the National Commission for Backward Classes, National Commission for the Protection of Child Rights, Chief Commissioner of Persons with Disabilities, Chairperson of the National Commission for Minorities, you are also the ex officio members of the NHRC. Clear? Important thing here is, every 5 years, listen to me carefully, this is where it becomes important. Every 5 years, there is an entity called Global Alliance for National Human Rights Institutions. This Global Alliance represents 120 national human rights institutions. 120 national human rights institutions across the world. And what is the responsibility of this Global Alliance? To review the functioning of these human rights commissions, whether they are in agreement with Paris Principles or not. If they are in agreement with Paris Principles, we will accreditate them. We will give them accreditation. If accreditation is A, it is the top rating. Which means if your National Human Rights Commission has A accreditation given by this Global Alliance, which means you can become a member and hold positions in this Global Alliance. Every 5 years, this Global Alliance reviews all these national human rights institutions. Initially, India was given A rating. Then we were up for renewal, review after 5 years. And for 2 consecutive years, Global Alliance has delayed accreditation to our National Human Rights Commission. If it is delayed, or if we are given B rating, that means we cannot hold positions in this Global Alliance. We cannot become a decision maker in this Global Alliance. That's very important. Why this has been delayed? Why this accreditation has been delayed? Because it is argued, Global Alliance says, some letters were also written to Global Alliance by Amnesty International saying Indian Human Rights Commission is under political control. It is not independent institution. It does not have investigative powers. It has to rely on police for carrying out investigation. So it is not independent. It is under the control of the government. It lacks diversity because minorities and women are not represented. That is why this accreditation got delayed twice in consecutive years. That is why this NHRC becomes very important. Okay? Great. Let's look at another topic, Foreign Contribution Regulation Act. This act was initially enacted in the year 1976, but then it was repealed. It was reenacted in 2010, and major changes again were made in 2019-2020, and FCRA is in the news for continuously for the last 2 to 3 years. What does this law primarily target? Foreign Contribution Regulation Act. Who are these individuals who can receive foreign contribution, foreign donation? Who are these entities which cannot receive foreign contribution? For example, the law says if you are the editor or the publisher of a newspaper or a cartoonist or a judge or a candidate contesting election, or a political party, you cannot receive foreign contribution under any circumstance. In 2019-2020, one more category was added, public servant. Now, even a public servant cannot receive foreign contribution. Then who can receive foreign contribution? Universities, non-governmental organizations. But if you want to accept foreign contribution, if you want to become eligible for foreign contribution, you have to apply for FCRA license. And without FCRA license, you cannot receive foreign contribution. And this FCRA license, which was provided to some NGOs, these FCRA licenses, which are valid for 5 years, were now eligible for renewal, but the government did not renew them. The government cancelled FCRA licenses of various non-governmental organizations, Center for Policy Research, Common Cause, so on and so forth. That is why this topic becomes important for your exam. Few important details regarding this law. Number one, previously and now means after 2020 changes. Previously, if this is an organization A and this is an organization B, listen to me carefully. Both of them have the FCRA license. That means both of them are eligible to receive foreign contribution. What if A receives 1 crores? It could have transferred a part of this money to B because B is also eligible, but it has not received foreign contribution. We will give it. Now this has been banned. That means if this entity has received foreign contribution, it cannot transfer a part of that foreign contribution to any other entity, even if that entity was eligible for foreign contribution. Number one. Number two, previously, if you have received 1 crores as foreign contribution, you could spend or you could have spent 50% for administrative reasons, administrative purposes, for example, rent, salary, so on and so forth. Now the law says you can spend only 20% on administrative purposes, not 50%. Previously, you could have opened a bank account anywhere, and in that bank account, you could have received foreign contribution. Now the 2020 rule said no. You can open bank account only in that which we specify. Which means now the government has said, you can open this bank account, but only in Delhi, which is near Parliament Street, and that is the branch of the State Bank of India. So previously, you could have opened any bank account in any bank, anywhere in the country to receive foreign contribution. Now, because of the changes in 2020, the government says you can receive foreign contribution, but only in the branch of that bank which we specify. And then we specified that you can open this bank account only in the Parliament Street branch of the State Bank of India in Delhi, and only in this account you can receive foreign contribution. If this FCRA license, as I told you, which is valid for 5 years, now before 5 years are over, I need to apply for renewal as well. And the law says within 6 months of the expiry of this FCRA license, I have to apply for renewal. But now the rules say, if you are applying for the renewal of this FCRA license, the central government may investigate, may conduct an inquiry before reviewing your FCRA license to see whether you are fictitious or benami. Maybe you are not doing any NGO work. It's a benami organization meant to receive foreign contribution and you are giving it to somebody else. Or you have been prosecuted for creating communal tension, or you are indulging in religious conversions. Are you using this foreign money to convert Indians to another religion? If that is the case, we will conduct an inquiry. If that is the case, then we will not renew your license. Or if you have been diverting or misutilizing your funds, we told you you cannot spend more than 20% for administrative reasons. If you're spending more than 20%, which means you are misutilizing the funds received through foreign contribution. Initially, the law said, pending this inquiry, your FCRA license could have been suspended for 180 days. The law, when it was changed in 2020, it says now it can be further suspended for another 180 days, making it very difficult for non-governmental organizations to receive foreign contribution. But these facts can be very, very important for your prelims examination. Okay? Great. Let's look at another topic. LG of National Capital Territory of Delhi versus the Chief Minister. Delhi is a union territory, but it has a Chief Minister as well, Legislative Assembly as well. And Delhi Legislative Assembly, you would know, cannot make a law on law and order, land, and police. Right or wrong? Right. Then matter went to the Supreme Court, and I'm sure you would have read that. In 2018, Supreme Court said no. The advice of the Chief Minister and the Council of Ministers is binding on the Lieutenant Governor. Then the question was on services. Who will have the power to appoint secretaries to the Delhi government? On this matter also, the Supreme Court said, no, this power is with the Delhi Chief Minister, Delhi government, not with the Lieutenant Governor. Except you don't have any authority over the IPS officers, over the police, because police is under the control of the center. But on all other matters, maybe chief secretaries, secretaries to various departments, it is the Chief Minister and the government which has the authority. Then Parliament enacted a law, and that law basically gave this power back to the Lieutenant Governor. And what was mentioned in that law, that can be important for your exam. Look at this question. The LG of NCT of Delhi enjoys discretion in which of the following cases? Summoning and proroguing the Delhi Legislative Assembly, recommendations of the National Capital Civil Services Authority. What is the right answer? Majority is saying B. This law, which was enacted in 2023, it says that the Lieutenant Governor of Delhi has the sole discretion even in summoning and proroguing the Delhi Legislative Assembly. That's not the power now with the Chief Minister, Mr. Previously Mr. Kejriwal, now Ms. Atishi. And even on the recommendations of the National Capital Civil Services Authority. So both these statements are correct. But sir, what is this National Capital Civil Service Authority? If Services Supreme Court said is under the elected government, the law was changed to say now that we will create a National Capital Civil Service Authority. And this authority will have the power to recommend to the Lieutenant Governor regarding postings of secretaries, transfer of these secretaries, whether we need to prosecute or officer under disciplinary grounds, except Indian Police, because that is under the control of the center. Officers who are serving in connection with subjects of police, public order and land will not come under this authority. Why? Because that is not under the prerogative of the Legislative Assembly. On all other matters, transfers, postings, disciplinary action will be under the control of the National Capital Civil Service Authority. And this authority will recommend to the Lieutenant Governor, transfer the secretary, post this secretary. But what will be the composition of this authority? It will consist of the Chief Minister, Principal Home Secretary and Chief Secretary of the Delhi government. And the decisions have to be taken by majority. Which means if two say that this person should be appointed and this person should be transferred, this recommendation will be sent to Lieutenant Governor. If Lieutenant Governor agrees, posting will take place. But Lieutenant Governor will have the discretion. It may even go against the recommendation of this National Capital Civil Service Authority. Interestingly, the quorum for this meeting is 2, which means even if the Chief Minister is in jail, doesn't matter, we can still perform our tasks, activities and recommend to the Lieutenant Governor who could be transferred, who could be posted. This is something important, can be asked in the examination. Okay? Great. Let's look at citizenship rules. Law was enacted called Citizenship Amendment Act 2019, which says that if you are a migrant from Pakistan, Afghanistan, Bangladesh, and if you have entered India on or before December 31, 2014, you are not treated as a legal migrant, because illegal migrants are not eligible for citizenship. But these migrants from Pakistan, Afghanistan, Bangladesh, who belong to the 6 religious minorities, Hindus, Christians, Buddhists, Jains, Parsis, Sikhs, if they have entered India on or before December 31, 2014, they are not treated as illegal migrants. When they are not treated as illegal migrants, that means they are eligible for citizenship. Through which route? Through the route of naturalization. But for that, how do we prove that you are from these countries, you belong to these 6 religious minorities, and you have entered on or before December 31, 2014? For that, rules are to be made. Rules were made in 2024. What are these rules? Very briefly. And please understand, if a question on this topic is asked, the very purpose of this law is to simplify citizenship for these migrants. So if there is any statement which you think is very difficult to achieve, the condition mentioned is very difficult, then you could assume that that statement is wrong. Because the government, by enacting these rules, by making these rules, has made it very easy for these migrants to get citizenship. That is why any certificate, any document which can prove that your grandfather or your grandparents or great-grandparents were the citizens of these 3 countries, we will accept that document and we will assume that you are from these 3 countries. So you have satisfied the country criteria. For that, we will not ask for your visa. We will not even ask for your passport. If you have passport or visa, very good. Even if that passport has expired, even if that visa has expired, doesn't matter. Any document which can prove that you are from these 3 countries, we will accept that document. To get citizenship through naturalization, one condition is you should have been well versed in any language mentioned in the 8th schedule of the Constitution. That's one criteria to get citizenship through naturalization. Previously, how do we prove? Or for others, how do we prove that you are well versed in a language which is mentioned in the 8th schedule of the Constitution? For that, you had to show the school leaving certificate. In that school leaving certificate, it should have mentioned that you have been studying Hindi or Gujarati or Marathi or Tamil. But now such a proof is not required for these migrants coming under CAA. Why? Because they just have to declare that we have the ability to speak this language. The mere declaration by the applicant is more than enough. We will accept that you can speak any language mentioned in the 8th schedule. That is why I said any rule which gives us a sense that it is difficult to get citizenship if this rule is there, you can say that this rule is not the rule, because the beautiful story is we want to simplify citizenship for these migrants. And there were some states, Bengal, Kerala and others, they said we will not implement CAA. That is not under the discretion of the states, because citizenship is the union list, union subject. And that is why previously the job of granting citizenship, giving the citizenship certificate, was with the district collector, who was reporting to the state government. Now, district collectors will not be involved here. There will be a district level committee and there will be an empowered committee. If you are from these 3 countries, you belong to these 6 religious minorities. If you want to apply for citizenship, which means you are an applicant, you have to apply before the district level committee. And then the final decision will be taken by the empowered committee. This empowered committee will be headed by the director of census operations, which is part of the home ministry at the center. So states have no role. This district level committee will have a district informatics officer of that district, nominee of the central government. So even here, there is the dominance of the central government. And it should be, because citizenship is the central subject, is under the union list. These rules, maybe, just glance through these rules, maybe you can expect a question. Okay. Let's look at another topic, Model Prisons and Correctional Services Act 2023. Prisons is a state subject, but Parliament has enacted a model law. That means all the states, if you want to enact a law on prisons, please follow the model law that we have passed in 2023. And what does this model law say? All the prisoners could be classified, should be classified into 4 categories. Those under civil cases, under criminal cases, if you have been convicted, or if you are under trial. And all those who are the prisoners, they may be further subcategorized. These are the prisoners who are drug addicts. These are the prisoners who are first-time offenders. These are the prisoners who are foreign prisoners. These are the prisoners who are suffering from mental illness. And these are the prisoners who are sentenced to death. Prisons may also be made separate for males, females, and the transgenders. So if the statement is asked in the examination, which of the following statements regarding Model Prisons and Correctional Services Act is correct? The law provides for a common prison for male, female, and transgenders. You have to say that this is not correct because it calls for a separate sections for male, females, and the transgenders. The law provides for the categorization of prisoners into 2, civil and criminal. You need to know that it is not only civil and criminal, it's also into convicted and under trial. Something else. Under trial review committee. Who are these under trials? You are accused in this case, but you are in jail. You are still not convicted. The trial is still not going on, or the trial is ongoing, but you are not convicted. You are still accused. Should you be released on bail or not? Maybe you cannot afford bail. But for that, the model law says that there should be under trial review committee. Question may be asked. This under trial review committee will be headed by the district collector. You have to know that it is not headed by the district collector. It has to be headed by the district and sessions judge. And it is this committee which will have to meet periodically to see who are these under trials and whether they are eligible to be released on bail or not. Because ideally, we have to declutter our prisons. Also, special watch and surveillance measures. This topic also becomes important because you may be, you may be aware of Lawrence Bishnoi, how from within the jail he is operating a gang, and which is also threatening Salmon Boy and various other Bollywood personalities. Some say he's a raw agent or whatever it is. But from within the prison, you are carrying out criminal activities, organizing gangs. This is where this model law becomes important and can be important for your exam, because it says that there should be a special watch and surveillance measure, CCTV cameras, close coordination with the intelligence wing of the state police, so that we can keep a surveillance over these inmates so that they do not gang up within the jail and carry out illegal activities while ordering these illegal activities from the jail. This is where this Model Prisons and Correctional Services Act becomes important. Let's look at another topic. Okay. Cabinet approved continuation of scheme for fast-track special courts. What are these fast-track courts? There are cases of assault against women, or rape cases against women, or sexual offenses against children. Such cases, if they go to the regular courts, the justice may be delayed because we have a large pendency of the cases. That is why in 2019, fast-track special courts were implemented as a centrally sponsored scheme. And you know, a centrally sponsored scheme is a part of this funding will be given by the center, a part will be given by the states. Look at the outlay. 1952 crore, 1207 crore from the center, 745 crore by the state. You don't have to remember this number. This is just to give you an idea that it's a centrally sponsored scheme, which means a part of this money will be given by the center, a part will be given by the state. And the central share will be funded from the Nirbhaya fund. That is important detail. Initially, the target was that we will have this fast track special courts only till 2023. Now it has been extended till March 2026. So Cabinet has approved continuation of the scheme to set up fast track special courts for those where violence has been committed against children or women, so that quick justice, swift justice is provided. Delays are minimized. Initially, the scheme, which was initiated in 2019, was meant to continue till 2023, but now it has been extended till March 2026. That is why it becomes important. Okay, let's look at zero FIR. What is a zero FIR? It was not mentioned in the Indian Penal Code, but now is mentioned in Bharatiya Nyaya Sanhita. You would approach the police when a crime has been committed, but maybe the crime has been committed in another police station's jurisdiction. This police station will not accept your complaint. Why? Because the police will say you go to that police station under whose jurisdiction this crime has been committed. But the concept of zero FIR was recommended by Justice Verma Committee. And Justice Verma Committee was set up in the aftermath of the Nirbhaya gang rape of December 2012. The Nirbhaya fund was in the name of Nirbhaya. So Justice Verma Committee recommended zero FIR provision. Zero FIR is, now if a crime has been committed under the jurisdiction of this police station X, but you approach Y police station, they have to register your complaint. Since no number is provided to this FIR, that is why we call it zero FIR. Then what this police station will do, it will transfer this case to police station X, under whose jurisdiction this crime has taken place. And now X will investigate this case. But to investigate a case, it needs to be registered first. Previously, it would not be registered because the police will say, no, I'm not going to register because it did not occur under my jurisdiction. Now you have to accept it. Don't assign it a number. It's a zero FIR. You transfer it to the relevant police station, and now the police station, that relevant police station, will carry out further investigation. This is what we call zero FIR. On the recommendations of the Justice Verma Committee, previously it was not explicitly mentioned under Indian Penal Code, but now it is clearly mentioned under the Bharatiya Nyaya Sanhita. Okay? That is what we had to discuss today. 14 topics, all important, which appeared in the news between January to May 2024. As I told you at the start, tomorrow and day after, Saturday and Sunday, Chetan Sir would come up with current affairs related to international relations from the period January to May 2024. And this is stage 1 of Conquer Prelims. In stage 2, I will come back, and in the stage 2, we will discuss high-yielding topics from Indian polity. We will focus on parliament, we will focus on state machinery, we will focus on judiciary, we will focus on Panchayati Raj institutions, we will focus on directive principles of the state policy, we will focus on center-state relations, we will focus on constitutional bodies. Then in stage 3, we will discuss previous year's question papers. In stage 4, we will discuss current affairs of the period June to April 2025. And in the stage 5, I told you yesterday, I will cover the bare act of Indian Constitution in a single class. So last quick revision before your prelims examination. So see you in stage 2, 3, 4 and 5. And if you're liking these sessions, do not forget to press the like button and subscribe to our channel if you haven't yet. Thank you for staying with me. Good night. Goodbye.